All right, we're live.
Hi everyone, thanks for joining our live stream. This one is about the NIW profile building and what to look for, what the trends are. We are doing an NIW workshop, like specifically focused on profile building in the NIW context. We're doing that tonight, so if anyone wants to join, we'll share the link and everything on the chat that follows this live stream. Feel free to visit my LinkedIn page and click on the link there. We'd be happy to have you join tonight. We still have some slots open for that. But NIW profile building is something that not a lot of people talk about. And I think one of the reasons that it's not talked about a lot is because it's impossible to gain certainty. Like in the context of EB-1 profile building, you at least know what criteria you're targeting. You at least have a goal. You have some standards and some benchmarks to look for. For EB-2 NIW, you don't. And that's part of the way the system is set up just legally. USCIS has a lot of discretion to consider whatever NIW cases they want to, and not a whole lot of guidance for how to make those decisions, and definitely no standards or benchmarks involved. All they have at the end is a balancing test where they're asking themselves the question of whether or not the United States benefits more by having you immigrate on your own merits, or if the United States benefits more by having you go through a labor certification process that's designed to protect U.S. workers. So that's a question at the heart of NIW, and that kind of balancing test doesn't really give you any ideas or any guidance for how to build the profile, right? How do you convince a USCIS officer that you warrant this discretion and this waiver, rather than having to go through the labor market process. So just to take a step back from that, when you take a look at the question like that, you have to consider that the labor market test, the labor market certification process, is something that is considered very important by the US government. And it's designed so that employer sponsors of individual immigrants, don't get to cheat the system and underpay immigrant workers or create different market conditions for immigrants versus U.S. workers. It's trying to protect U.S. workers from being totally undercut and totally out of jobs. So it's focused on companies. It's designed to describe particular jobs, particular sets of job duties, particular functions at particular companies, and it's not focused on the individual at all. The company and the government actually are not allowed to take your individual contributions, your skills, or anything related to you particularly into account during that process. So if you are just doing a traditional job, if you are totally focused on performing your 9-to-5 job duties, and you are performing a particular function within a company that is pretty standardized, that can be advertised to U.S. workers, that a U.S. worker could fill, you are not a good candidate for NIW. And I mean, that makes sense. That's only fair. That's the way the system was set up. That's the way the law was written. For profile building, if you are in that category where you really are just focused on your 9-to-5, profile building is about showing that you have more to offer the U.S. and that you will actually offer it and you will do things that are important to the U.S. in the future. So profile building in that context means that you need something outside of your job. You need to demonstrate some kind of contribution or benefit outside of your job in order to be considered for the favorable waiver and the grant of discretion. Or I said that wrong. The favorable discretion and the grant of the waiver. So in that context, it's very, very straightforward. What you need to do for profile building is to get really involved in some other area and show that you are benefiting and contributing outside of your 9-to-5 job. This gets a little bit more difficult when we consider other scenarios. Like there are people who just do their 9-to-5 job who are granted NIWs, and they tend to be in jobs that we definitely consider in the U.S. to be of national importance. Like if you are a cancer researcher and you're working 80 hours a week for some famous research hospital, you probably have a really good case for an NIW, just because it's obvious that you are contributing in a very important way. And the skills that are associated with research tend to be more individual, where sure, the job duties can be cookie cutter, where you are in the lab for this many hours, you are doing clinical trials or experiments or research in this many hours, but the actual work that is being done is in your own brain. Like, it is tied to you. It's not something that you can just sub in any other person to do. And so those types of roles work well for NIW. Traditionally, those jobs would have been seen as really good for NIW, but even with the trends now, USCIS is looking at things more from the standardization process, where if you are just contributing to your employer, they will say you need a perm and a labor certification, even if 5 years ago they would have approved your case easily. So even people who are working in those areas that typically would be considered of national importance and typically would qualify, they need activities that are outside of their job as well. And a lot of times for researchers, that just means publishing papers, getting citations, participating in peer review, doing things that are contributing professionally to the whole field and to the knowledge that is in the whole field, and not just working for their employer. This definitely complicates things for researchers who are working at private companies that don't put out their research but keep everything proprietary. We've seen a lot more denials even in traditional areas. But if that's you, if you're working for a company and you're a researcher, get out there, try to do some kind of professional service. Even if you can't publish your research, try to see if you can get involved in a professional organization. Do some mentorship. Demonstrate to the United States that you are not just part of your company, that you have unique benefits to offer that are only something that you can do. All right, so then for everyone else, the profile building for NIW isn't going to guarantee you an NIW approval. I think that's very, very important to state right off the bat. It's not going to guarantee your approval. Before, I would say in 2023 and 2024, profile building was very, very good for your case and could make your case like a 90% chance of approval, 95% chance of approval. Like, you could definitely do things to take things into your own control and improve the case very, very significantly. Now, the profile building that you do is mostly targeted towards prong 2 of the 3-prong DANISAR test that's involved in NIW. If you want to meet prong 1 or prong 3, it's very arbitrary right now. Very, very, very arbitrary. So profile building will improve your chances, but not guarantee your chances. With that in mind, NIW is still something that many of you will have to do because perm is not going to be an option for you, especially in this job market. So I recommend that anyone who is considering NIW, or basically anyone who does not yet have a perm-based I-140 approval, who is 3 or 4 years away from maxing out on their H-1B, look at NIW and start profile building for NIW. You may need it, and profile building is one way to ensure you have a stronger case, or at least that your case is as strong as possible when you get to that application stage. If you're in tech, this might mean doing a lot of things related to professional service that are outside of your normal area of work. So you will want to participate in professional organizations. If you can publish work and share your knowledge, that's really good, even if it's not in research journals. If you want to do things like judge hackathons, mentor others, speak at conferences, or even at informal workshops or meetups in your city, any kind of professional participation helps with the NIW profile building. And then if you're in any other field, and this includes fields as varied as arts, public speaking, influencers, entrepreneurs, any field that you can think of, just get involved outside of your 9-to-5 so that you can demonstrate that the U.S. has a vested interest in keeping you, and that your efforts and your contributions are not just tied to an employer. So the labor certification is not actually what the United States should be looking at when looking at your case. All right. So that's probably good. It's a good overview for NIW. I guess we didn't get so much into the details of it as the why of it all, what you should do and what some of the trends are. how you should look at it and why you should do it overall. We can go into questions, and just remember the workshop that we're having tonight is going to have more of the how. Like what activities should you do? What specifically should you target? The workshop is really, really helpful for that, but it needs to be in a longer format than just the live stream. So Jason, we can go into questions here.
NIW I-140 pending since last 8 months, so what would you suggest at this time, given filing a premium might lead to an RFE, as officers might not be reading the petition carefully?
I mean, it really depends on your own circumstances. You've been waiting at least 8 months, so the decision could come any day. Premium processing might not actually speed up the decision, because if they're ready to make the decision in 30 days and then you upgrade a premium and then they decide to put it on a 45-day timeline, it's not necessarily going to move faster. At the same time, some NIWs take more than 2 years, so you never really know. Premium is the only way to guarantee a timeline. That's the main function of premium processing. As far as premium leading to an RFE, I don't think I see this as strongly as other attorneys do. I think premium might slightly increase the chances that you're getting an RFE, but you still see RFEs on regular filed cases. It's not like premium processing is the thing that triggers that. You also, on regular filed cases, still see officers not reading the file. You still see officers issuing RFEs or denial notices with other people's information, other people's job titles, things that are not relevant to the case at all, or so vague and generic that they could be applied to any case and not just yours. So premium is not necessarily the trigger point for that. And I don't have advice for you specifically without knowing why you need the expedited decision. I guess in general, if you don't need the expedited decision, just keep it in regular. But most of my clients end up filing in premium because most of them need that decision in order to plan the next stages and do other things in their lives.
NIW I-140 petition filed by the employer is pending. If I wish to file another NIW I-140 in parallel under premium processing, can you help leveraging and modifying the already submitted petition docs?
Yes, so you can always file on your own, and you can do that while the employer petition is pending, or before it's filed, or after it's approved. You can do it anytime. The individual petition does tend to look a little bit different than the employer petition. So it's not usually a matter of just repackaging and submitting the exact same materials. You usually do need a little bit more case development because you're presenting your personal side of the case and your personal argument, and it's not just related to your job. If you want to email me and provide me with copies of everything that was filed, I can then take a look and provide a custom price quote and time quote. And I do this for a lot of clients, but each case is different. So this part is not standardized. Our filing fees, like our typical filing package, is pretty standardized, and our prices are listed on the website just for transparency. But if you want a discount from that based on things already being done, that needs to be a custom quote.
Okay, this answered. Any letter from state senator help expedite the NIW I-140 processing time reduction for pending petitions?
I've never seen this work. I guess it can be worth a try. I think getting the state senators to regularly say that USCIS is taking too long is probably overall good for the agency to hear, because Congress does have some oversight ability over USCIS. So I'm not saying not to do it, but I am saying temper your expectations, because the Congress people usually get back communications from USCIS that are slightly more polite, but are the same kind of denial or just saying this is normal processing for us that everyone else gets. So it's pretty rare for it to actually work. You should still do it, but just temper your expectations there.
Is there any pre-review phase in the whole review process of the petition?
sure what question or what this means. If you can clarify, I can try to answer that one.
With the slight retrogression for August and possibly unavailable for September, do we see an increase or decrease in the waiting time for EB-2 in fiscal year 2026?
We don't know what fiscal year 2026 will look like yet. The retrogression and the slowdown at the end of the summer always happens, or I shouldn't say always, happens most years. Because USCIS is supposed to use up all of its numbers, and so they need enough cases in the pipeline to actually use their numbers. So usually by the time September rolls around, they're making really good progress on meeting the year's quota, and so they can't, they have to do retrogression. They have to slow down the pipeline to some degree. And then in October, it opens up again. So usually the October visa bulletin is what we want to look at as far as seeing what the trend will be for the next year. And using August and September to predict next year is not very helpful. It has very limited use.
Can you suggest where one can find examples of recently approved STEM NIW I-140 petitions on USCIS website or otherwise?
No, you can't view this data. I mean, they don't publish why they approve cases, so you don't get a decision like you do with the denial decision. You just get you just get the approval notice. That's it. So there's no database or anything like that.
Can you share your email address, please?
Yeah, you can visit the website, waypointimmigration.org, and contact us through there. That would be helpful.
USCIS and I-797, does this mean that my application in terms of forms and fees are valid and now adjudication is based on merit?
I mean, it should mean that. Does it always mean that? Not necessarily. It should mean that they're not rejecting the case, although I have, in very rare cases, seen a rejection after a receipt was issued. So you can rest easy for now, but just know that things can be unpredictable all the time. So I can't guarantee that it's going to go smoothly and be a merits adjudication at this point.
I'm a physical therapist and looking for EB-2 NIW. How can I build my profile to be eligible? Can you please give some ideas?
So I would really recommend, if you're a physical therapist, to look into the employer-sponsored Schedule A process. It's really difficult for physical therapists to get NIW. And the same is true with nurses who can also go through the Schedule A process. It's not impossible. I've seen both nurses and physical therapists get NIWs approved. But since there is that alternate labor certification process, USCIS is almost expecting that you go through that process and take advantage of it. And so for you to do an NIW, I think you really need to build your profile, and you need to stand out as someone who's really unique in the physical therapy that you're doing, whether through research or through some novel technique that you developed or through entrepreneurship and setting up your own clinics and expanding those clinics. You will need something like that in order to qualify. If you want to do normal physical therapy practice, get an employer sponsor and do Schedule A.
Do Nebraska centers have more proclivity to reject petitions than Texas?
So your language here, when you say reject, makes me think that according to the earlier question, you're talking about a mailroom rejection and not a denial. But it's not totally clear from your question. So just so everyone knows, in immigration law, when an attorney says reject, they don't mean deny. They mean that the service center sent back the materials and said, we're not even accepting this filing because it's incomplete. A denial is when they actually look at the merits and issue a decision on the case. I think this person clarified at the bottom. So they meant deny the case. Does Nebraska have more proclivity to deny the petitions than Texas? I don't think so, at least not for NIWs at this point in time. They have a slightly worse reputation on EB-1As, but not so much on NIWs. Honestly, I've seen pretty equal results from the service centers so far on denials of NIWs.
Means pre-review of the package I-40 where officer check eligibility and objective evidence and pass to any other officer, trigger RFE if something is incomplete at early stage.
There's a mailroom review so that they make sure that the application is complete. But typically they're just checking that the filing fees are there, the forms are complete and on the right edition. Things aren't obviously missing from the file. Like if you send in just the forms and no supporting documents, they would probably reject that, saying like something's missing here. But they do not check eligibility or objective evidence. And like they might change their processes here and there. It's not like USCIS puts all its processes out online. So I have limited visibility as well into what their processes are. But it's my understanding that there's a mailroom review, then the case gets assigned out to an officer, and then that officer does all of the review. And they can go to their supervisor if they need second level review or something like that.
All right, let's do one more question.
Yeah, we need to leave in just a minute or two here.
Or I'll do this one. Are you seeing cases of H-1B holders being called for court appearance during the 60-day grace period for possible deportation proceedings?
So we had one consultation where we saw this. It was a very, very odd situation. It's not widespread. So this should not be something that people are too concerned about and just generally aware of. If you do get an NTA, just contact us. We can work with the court to potentially get that dismissed or show up in court and explain why it's ridiculous because you have an application pending. At least in most cases, you have an application pending. But yeah, I would definitely not panic about this. Just be aware and then contact us right away if you see it happening.
All right. Thanks, everyone.
Thanks, everyone. Feel free to join the workshop tonight just via that first comment. We'd be happy to have you, and we can talk in more detail about NIW profile building.
Thanks, everyone.